Here we go. Right, so I suppose this could be the pandemic case law seminar, because all of these decisions actually occurred or through the pandemic, and most, I think, were actually virtual hearings. So yeah, much has changed even for the courts. So the first one I've got is ISG construction and platform interiors. So this was a Part 8 claim relating to an enforcement of an adjudicator's decision that had already been handed down. So often you get the Part 8 and the Part 7 together, but this time the Part 8 followed. So it sought declarations that the decision was wrong and beyond rational justification. Platform were not entitled to the sums awarded. Platform were not entitled to judgment enforcing the decision, and the purpose of the action was purely to prevent enforcement. So the background to this is that the subcontract was terminated. The contract clause 27.4 required the subcontractor to submit its final account within 14 days of the date of termination. Clause 27.5 of that contract entitled ISG to recover any cost from the subcontractor in terms of all losses, expenses and damages suffered by reason of the termination. So ISG's case was that the adjudicator had not valued the works in accordance with clause 27.4. Instead of a payment to ISG, which they thought they were going to get, the adjudicator made an error and decided Platform would due a payment of something in the order of 400,000. So given that they terminated the contract and they were paying another contractor to complete Platform's works, they were expecting a payment, but the adjudicator decided completely the reverse way round. I think that the way this occurred is that the adjudicator, quite well-known adjudicator and a quantity surveyor, had been sort of misled by the parties, and they just took the total costs minus the total value. And because of the main contractor hopefully has bought his subcontractor at a profit, the cost was much lower than obviously the value, and so it reversed the whole number of the figures. So it had a slightly bizarre consequence, really. So within the judgment, there was reference to a number of judgments. So Hutton Construction and Wilson Properties, that was from 2017. Makeup Civil Engineering and Morrison, which was the groundbreaking case 20 odd years ago now. Bouygues and Dahl Jensen in 2000, and Carillion and it should be Devonport, Royal Dockyard 2006. So the adjudicator's decisions have been upheld where the need to have the right answer has been subordinated by the need to have an answer quickly. So even where the adjudicator has been shown to have made an error. There are two exceptions, and this is from the Hutton case. So an admitted error. So that was from Jeffrey Osborne and Atkins Rail in 2010, and the proper timing, categorization or description of the payment notice or pay less notice. There is also an exception if the issue is short, self-contained, requiring no oral evidence, than provided during a short interlocutory hearing. The defendant may be entitled to have the point decided by way of a declaration. So that's the normal Part 8 procedure. So these principles were then subsequently applied in an unreported case of C-Down Developments and SMCC Construction. It does not simply follow from the fact that the adjudicator's decision is wrong that it will not be enforced, save in the sort of a particular or exceptional circumstances identified by Coulson J, as he was then, in Hutton, for the very reason that normally the fact that the adjudicator may be wrong does not render his decision unenforceable. So the first exception here then, so with regard to ISG and Platform, the parties had agreed the way in which the adjudicator should approach the valuation, and it gave a result neither expected. So although the adjudicator had made an error, the actual parties had directed the adjudicator down that particular path, it would seem. And the second exception, ISG needed to go further than establishing the correct approach, but to show the amount which would produce a different result that would require value, and that would require valuation evidence, which you can't hear as a Part 8. So ISG didn't actually set out what the figure should be. So Judge Tahar QC decided that this was not a case falling within the two exceptions stated by Coulson J in Hutton. The declarations sought within counsel for ISG skeleton argument were wider than those sought by the details or in the details of claim. So counsel was going much wider than had been set out in the particulars. And given that ISG cannot bring themselves within those exceptions set out in Hutton, it would be wrong to grant the declarations sought. So in that case, the judge actually decided that money should be paid across to platform, even though it was clearly wrong. So it's the pay now, argue later approach, which the courts have continued with over the last 20 years. Right, so the next case, there's elements that are in some ways similar to the last one. So this is J&B Hopkins Limited versus Trent Engineering. It's a smash and grab adjudication, no payment or pay list notices. There was a considerable sum due though. Adjudicator awarded over 800,000. The defendant failed to pay and the claimant issued proceedings in the TCC. So the contract, so the works, M&A Works, a recycling plant on the Isle of Wight. It concerns an application of payment number 26 dated the 30th of July 2019. So there is no payment notice. The claimant relied on section 110(4) of the Housing Grants and Construction Regeneration Act, and the notified sum was the application number 26 for the purposes of section 111 of the Act, so the default notice. There were no jurisdictional challenges, and the defendant fully participated in the adjudication. The claimant sought summary judgment for the adjudicator's decision, and the defendant resisted payment as it was overtaken by subsequent interim payments. So this must happen time and time again on construction sites where you have a dispute, but by the time you've dealt with the dispute, you're onto the next or even the further application for payment. So the applicable law, again, Mackov and Morrison, so adjudicators' decisions will be enforced regardless of errors of law or fact, and is now over 20 years ago. More recently, Hutton Construction again and Wilson Properties, where Mr. Justice Coulson, as he was, if the decision was within the adjudicator's jurisdiction and the adjudicator broadly acted in accordance with the rules of natural justice, such defendants must pay now and argue later. So again, those are the exceptions: the admitted error or issue of a parte proceeding seeking a determination on a self-contained legal point concerning timing, categorization or description of the payment or payless notice. Case also referred to PBS Investor in 2018, and another quote from the judge in that case: adjudication is all about interim cash flow, and it is routine to enforce decisions that require substantial allocation of cash to one party or another in the knowledge that it may prove to be merely an interim measure. The fact that the basis of the adjudicator's decision is to be challenged in other proceedings is of itself seldom, if ever, a ground for non-enforcement. So you can see the theme here coming across, can't you? So the issues on which the defendant resisted summary judgment, quite a few. So its application 26 was superseded by subsequent payless cycles. Don't all laugh. Adjudication commenced on January 2020. The claimant had gone along with subsequent payment cycles, and they were now up to payment application number 33. The judge referred to this as a novel point. I think the judge was quite annoyed by this, so he referred to it as a novel point that was being argued by counsel. Another adjudication was in progress, which will determine the extent to which the claimant is entitled to payment of further sums. So the true valuation was already in progress as an adjudication. It was manifestly unjust to permit the claimant to enforce PA 26 decision, and to enforce would be inconsistent with and undermine the correction principle that the payments can be corrected next time. So these are all the issues that the defendant was trying to run to resist summary judgment. So following the Court of Appeal decision in Grove, Lord Justice Jackson said that there is a correction principle where the true value of the works is permissible on later application. However, the amount due on the original application falls due because a failure to issue requisite notices. The correction principle cannot be applied to lead to the result that the amount was not due at all. So the fact that it was an interim application and that the amount can be corrected later does not assist Trent on this enforcement of the adjudication that was due to be paid on application 26. So there's no way that the courts are going to stand by and let sort of technical issues like this get over the sort of policy, really, with pay now, argue later. So undermining the correction principle. So we have adjudication at any time. Disputes on earlier applications could be substantive ones and do not cease to exist on subsequent applications. Due to the payment cycle, it is not possible where there is no payless notice to commence an adjudication, obtain a favourable decision, and enforce it before the next application falls due. It's just ridiculous, isn't it? This novel approach would be procedurally unjust and undermine policy of over 20 years. There was also an application for a stay on the basis of manifest injustice. So again, they quoted Interserve Industrial Services and Cleveland Bridge from 2000. So in that case, the judge said, where the parties to a construction contract engage in successive adjudications, each focused on the party's current rights and remedies. In my view, the correct approach is as follows. Absent special circumstances, the losing party must comply with the adjudicator's decisions. He cannot withhold on the grounds of his anticipatory recovery in a future adjudication based on different issues. So in terms of this case, the judge said, I do not accept that by participating in the subsequent payment application, the claimant lost its ability to adjudicate. There is a danger that in considering a stay where the claimant has a valid adjudicated decision of using the concept of manifest injustice as a wider examination of the merits of the underlying dispute, this would frustrate the purpose of the Act. So serving the relevant and required notice is not impossible, nor a Herculean task, said the judge. So he wasn't best impressed with all this, and he granted summary judgment, and the defendant's application for stay was dismissed. So probably nothing particularly unsurprising in those two cases. Now this is quite an interesting one in that it brings us into, I suppose, the 21st century and waste from energy. So Energy Fabricon Limited versus MW High-Tech Projects. So the issue, whether the primary activity of an energy from waste plant is power generation or waste treatment. And I can see this coming up many times in the future. So it was for a consolidated claim of 367,000 or thereabouts. MW, so they said that, right, Section 1052C of the Housing Grants Construction Regeneration Act provides that such works are not construction operations, therefore no strategic right or contractual right to adjudication. So this is one of the exemptions from adjudication, which is plaguing the courts and people that operate within construction, I think. And I think the judge, in looking at this case, was virtually saying that we need to address this point. There shouldn't be this exemption from sort of power companies to sort of frustrate the adjudication process. Anyway, Fabricon, again, the subcontract was for the installation of a plant where the primary activity is the disposal and thermal treatment of waste. Electricity generated from the electricity is generated from the processed waste. So it wasn't the primary activity. The primary activity was waste disposal, as far as Fabricon were concerned. Therefore, within the Act, therefore it was within the Act, and there was a valid provision for referring a dispute to adjudication. So MW contended that the adjudicator lacked jurisdiction as the primary activity was power generation. The facility is a fluidized bed gasification facility. Easy for me to say. The process used refuse-derived fuel, or RDF, to produce steam. The steam drives the gas turbine to produce the electricity. So nothing particularly clever there. The subcontract was an ICME yellow book and was for the installation of a gasification plant as part of an EPC contract. So the background to the actual dispute. So there are two adjudications concerning two separate interim applications. The adjudicator found in both cases for Fabricon MW participated in both adjudications, but subject to jurisdictional challenge. The subcontract works were not within the meaning of the construction operations for the purposes of the Act. So they're saying it fell outside of the Act because it was for power generation. MW failed to pay and legal proceedings were commenced to enforce. So it's found that the EPC contract was very strong evidence that the primary purpose was energy as opposed to waste. This description in the EPC was that it was a gasification plant receiving RDF, i.e. the fuel, that has been pre-treated. The performance of the plant is measured by reference to the heat and energy production rather than waste throughput. And the overriding contractual requirement was to operate as a power plant. And as a part of the specification, if the plant didn't generate to the required level of power, then the owner could actually hand it back. So that was another issue. The EA permit was for a waste incineration plant, but this status was changed from disposal to recovery. So it went from waste to power recovery. The plant was for the plant was not for any particular waste or energy policy. The planning application identified as both waste and power plant, and the funding model estimated most revenue was going to come from power generation. So the decision of the judge, so he decided that the primary activity was in fact power generation. The subcontract works do not constitute construction operations within the meaning of the Act, and therefore no right to adjudicate. The adjudicator did not have jurisdiction, and awards made in both adjudications were therefore unenforceable. So Fabricon's claims were dismissed. So that's a bit of a blow really for contractors that work in or on power sites that they're sort of getting excluded on this waste energy type situation. It's more work for the courts and more work for claims consultants and lawyers. So some win, some lose, I guess. Q Holdings and Donald Insel Associates. So again, concerned works at King's Observatory in Richmond. So Insel were the architects, and it was for the conversion and refurbishment of the property. And this dispute started as a dispute over unpaid fees, and Insel referred the dispute to adjudication and were awarded something in the region of 200,000. Q failed to pay, and summary judgment was granted against them. Q's application for appeal was refused by the Court of Appeal, and Q failed to pay the judgment sum. So they just got a judgment sum and they still wouldn't pay. So the court granted interim and then a final charging order over the property. Insel commenced a Part 8 proceeding for the sale of the property to enforce the judgment sum. Q opposed this on the grounds that it had a claim for damages against Insel for professional negligence and breach of contract, so it was an equitable set-off. So Q commenced proceedings claiming damage of something in the region of 2 million. So the Insel made the application that so that Q's claim should be struck out unless Q pays Insel the sums it had been ordered. Alternatively, a stay should be granted of the proceedings until Q pays. And they also require security for costs of some 700,000. The owner of the property was based in Hong Kong, so there were some issues as to whether it would pay, plus all the difficulties that Insel already had in trying to extract money from him. So the strikeout. So reference was made to S&T and Grove and the Davenport cases. Again, strongly on the pay now, argue later. Must pay the payment before commencing a true valuation adjudication. However, the court has already enforced the adjudicator's award, so you didn't have to consider any of that. There's nothing in the Act or authorities to render these proceedings unlawful or an abuse of process, as the interim binding nature of the adjudicator's decision contemplates legal or arbitral proceedings. However, Q has shown a deliberate, persistent refusal to comply with the court order. The judge stated that it is unreasonable and oppressive behaviour to pursue its claim in damages without first honouring the decision. However, striking out the claim would be too draconian. So what the judge then did was it ordered a stay of the proceedings pending payment of the outstanding judgment. The strikeout was dismissed and awarded 600,000 for security of cost to be paid into court, because, as I said, the owner of the Q Holdings was very wealthy, but wasn't paying, resided in Hong Kong, and the judge thought that he was never going to pay anyway, so hence the security of costs of 600,000. It was reduced for 700,000 because, based on the cost estimate, the judge thought that it would probably be a bit lower anyway, so hence the 600,000. Which I pretty much said there, I think. So that was that. So Insull got a decision in its favour. Now this one, a colleague of mine, or a friend of mine in Chambers, dealt with this one, and it was an absolute nightmare for him when he was doing it. So he used to ring me and ask me bits and pieces about it. So it's a bit of a nightmare case. So Lane End were the main contractor, and Kingston the subcontractor, and it's for a housing development up in the northwest, Cheshire, I think. So there were two claims. One was a Part 8 claim for a declaration and a decision of the adjudicator awarding something in the region of 359,000 not to be enforced and set aside, and the Part 7 claim for payment of the 359,000. So we've got one wanting to enforce the decision, one doesn't want to. So the main issue, whether the adjudicator had jurisdiction. So the adjudication was under the scheme. On the 2nd of March 2020, Kingston issued application number 17 for 356,000. There was no payment notice, but a payment notice was issued, but not until the 26th of March, so it was too late. On the 20th of March, Kingston requested the appointment of an adjudicator from the RICS. Later the same day, a meeting took place between the parties, in which a representative of Kingston gave Lane End a notice of referral, as it was called, not a notice of adjudication, regarding its failure to pay. But subject to the timing issue, it was otherwise, as far as the judge was concerned, a notice of adjudication. It later emerged in proceedings that the representative of Kingston had covertly recorded the meeting, which took up quite a bit of court time dealing with that as well. So on the 23rd of March, Mr. Jensen, got a well-known adjudicator, advised the parties of his appointment as adjudicator. On the same day, the referral was sent in. Lane End reserved its position regarding the adjudicator's jurisdiction. It was really the jurisdictional reservation was really because Lane End thought that the notice didn't go far enough to become a proper notice. The adjudicator advised that the notice contained a clear intention to refer the dispute described. So, and this was sent by email. Now, this is another issue, I think, where you have info at whatever your company's name is. It goes into a big box that hardly anyone probably looks at. So this was another issue here. But an automated email from Lane End advised that due to the COVID-19 pandemic, they were closed for business. So Mr. Jensen took that to mean that the adjudication was terminated, and he emailed back confirming the same, and that Lane End were responsible for his fees. Lane End did not notify Kingston until a week later. So he hadn't simultaneously sent his email to Kingston. Then he found out a week later. So when they did find out, Kingston's representative requested that the adjudicator continue and issue his decision. He then advised that as Lane End was not closed for business, that he now found out, and he had not resigned. So he carried on and he issued his decision for 356,000. So the issue of the covert recording. So as far as the judge was concerned, it was only of limited probative value. The defect arose from the sequence in which Kingston served the notice of adjudication and request for an adjudicator. So they got it round the wrong way. To admit the evidence would give rise to procedural unfairness. So what the representative of Kingston had done, he had used the recording to make his witness statement. So what that meant was the judge effectively threw out his witness statement because it had been based on his covert recording. Counsel for Lane End brought in all these other issues concerning the Human Rights Act, GDPR, that they were unaware of these recordings. It was interference with their privacy rights under the Article 8 of the ECHR. And as the judge had said, it would have been better and good practice if Kingston representative had advised those in attendance that he intended to make a recording. It makes common sense, really, doesn't it? But there you go. Was the adjudicator validly appointed? So paragraph 2.1 of part 1 of the scheme provides that the referring party is to submit its request for the appointment of an adjudicator following the giving of a notice of adjudication. If the request was made before serving the notice of adjudication, which it was here, then the adjudicator was not validly appointed and did not have jurisdiction. So there's reference to Vision Homes and Lanksville Construction, where the referring party in that particular case revised its notice 18 minutes after the request for a nomination. The judge in that case accepted the adjudicator did not have jurisdiction. So even 18 minutes later, that wasn't good enough. And in the decision, in the present case, the request preceded the notice of adjudication. For that reason, any appointment under the request could not take effect as an appointment in the adjudication. So since Mr. Jensen was appointed pursuant only to the request, his appointment was void. Since it was not pursuant to a statutory notice of adjudication, the RICS nomination was not capable of conferring on him jurisdiction. He was not appointed at all. Thank you. So quick canter through about 5 cases.
Thanks for that, Trevor. I was actually involved on the Isle of Wight project.